Welcome back to Land Law Made Simple. This is now the fourth lecture on land law, and we will have a look at severance today. So this is basically how we convert a joint tenancy into a tenancy in common, but let's have a look at that in more detail. So, what is severance? If you've seen my last video, you will remember that a joint tenancy is where everyone owns the whole property. So, for example, imagine if you and your friend own a cake house together. Like, could be a little like gingerbread house that you see at Christmas time, or I don't know, a bit more of a layer cake, something like that. Anyway, so if you are joint tenants, you don't each own just one slice or one portion of that cake, but you will both own the whole cake together. And because you own the whole item together, this also means that if one of you dies, the survivor gets the entire cake. So that's what we know as the rule of survivorship. Basically, in land law and property terms, everyone owns the whole lot, and that means that in case something happens to you, one person dies, the whole property still remains in the hands of the surviving tenant. It doesn't get separated. It's not something you can give to an heir, nothing like that. It just remains with the remaining tenants, the surviving tenants. Now, a tenancy in common is very different, because each person owns a defined share, or in the terms of our, like, let's say cake, each person owns a specific slice. So it could be that each of you own half of the cake, or it could be that I don't know, one only owns a very slim slice of the cake and the other one the big lion's share, because they made a lot bigger contributions towards the deposit and mortgage payments and so on. So because it's a tenancy in common and everyone owns a specific slice or a specific share, that means that this can now be inherited, and it doesn't automatically go to the other co-owner. Okay, so remember those two concepts from the previous lesson. Now, what is severance then? Severance is the process how we can change from a joint tenancy to a tenancy in common. So we basically go from everyone owning the entire thing to now cutting everything into slices, dividing the shares and allocating the shares as well. Okay, so that would be basically in a nutshell what severance is. Important things we need to know about severance. Okay, so this only happens in equity. Remember from the beginning, the legal title is always held as joint tenants. You cannot sever the legal title, it will always stay like that. Okay, so the official ownership and all the admin rights and whatever that come with it, that's always held as joint tenants. Severance only applies to the beneficial interests, so who gets to enjoy the benefits of the property, who gets to live there, for example. So that's the main thing we need to keep in mind. The law always forces co-owners to hold the legal title together. It's only behind the scenes with the beneficial interests that those can be actually split by way of severance. And this obviously must happen during the lifetime. Okay, so it must happen while the tenants are still alive. In order to take effect. You can't just say in your will that you want to inherit and you want to give the share that you own to I don't know, your son or your daughter or so, whatever you want, because that is not allowed in a joint tenancy. If you want to do that and you want to give your share to a specific heir, you will have to do the severance beforehand, before you die. Otherwise, it cannot take effect, as can be seen from the case of Carr versus Izard. Now, there's a few ways that severance can happen. The first four that you see here are the more common ones. We've got written notice, we've got mutual agreements, we've got acts on your own share, and you've got a course of conduct. And then we also have three more, which are more about circumstances that might happen, and less like actual actions that you can take regarding the property. And those three would be bankruptcy, homicide, or money management issues. Let's have a look at each of them in more detail. So, what's for written notice? This is probably the most complex one out of all the methods for severance. And the reason being is that you can just decide to do this on your own without even consulting with the other tenant. So, in a nutshell, you're basically just writing to the other tenant, the other co-owner, that you want to end the joint tenancy and that you want a separate share. Okay, so that's basically the idea behind it. You say, I want to sever this, I want my own shares, and I don't want to co-own this with you anymore as a joint tenant. Now, it doesn't have to be in a deed, it doesn't have to have fancy wording or a signature or those kind of things. But you must show that you want a severance to happen immediately. It doesn't work to say, oh, when I die, I want to sever my share, or I don't know, when I finish uni, I want to sever my share, or anything like that. It has to be something that's immediate, otherwise the notice will basically be void and not take any effect. as I already said, the reason why there's different rules for written notice is because it's a unilateral act, and you can do that even if the other tenants don't agree to it. Now, as you're talking about written notice, there's a couple of rules depending on which mail service and so on you choose. So this gets a bit more detailed and complex, but it's not that difficult to understand. But it's just something you need to learn because it works a bit differently to, let's say, contract law or other areas of the law. So in land law, we actually distinguish between the kinds of delivery. If you, for example, decide I want this to be a recorded or registered post, you write up the document and then you send it, for example, via mail, using a special delivery or a signed for letter, anything where you can track where it's going, and you know that in everything being normal, it will be delivered. Maybe you even get a notice that the item has been dropped off or something like that. In that case, you can assume that the notice is effective immediately upon sending and registering it, provided, of course, you've got the correct address and so on. It doesn't really matter if the other person then opens it or not, or it can potentially even get lost or be undelivered, as long as you still believe everything is going correctly and there's no notification by the Royal Mail that there's been an issue with the parcel, that kind of thing. It counts as received as long as you send it correctly and it's not returned to you undelivered. Now the other way obviously is if you just send it with a normal letter service, I don't know, something that's not tracked, something that's not signed for, just ordinary post. And in that case, the notice will only count as delivered if it's actually left at the person's last known address and it actually gets there and they have it, I don't know, at their I don't know, living property, their house, whatever. And yeah, even as before, if they don't open it, that's their fault, it was the account. So in theory, there's no need really for the other person to be actually aware of the severance. Okay. Let's have a look at an example. So we've got two shared owners, Martin and Jeff. But Martin says, I don't want to be a joint tenant anymore because I want to sell the house next year and then I want to split the proceeds. And he's sending that by a recorded post. What do you think will happen if we've got a text like this, and Martin wants to provide written notice? So the problem we can see is that the wording wasn't immediate, because he said in a year's time I want to sell the house, but that is not allowed in land law because it needs to be immediate, so the notice will basically be invalid. Otherwise, he's done everything he needed to do, recorded post, we assume he's addressed it correctly and so on. That would be sufficient, but for the one problem we have, that it wasn't immediate. Okay, so because the notice is then invalid, both of them remain joint tenants in equity. Okay, so the next method of severance would be acts on your own share. Something that's also called as alienation. Sorry for that typo there. So what is an act on your own share? Basically, it's if you sell, gift, lease, or mortgage your equitable interest, that then severs it and it becomes a tenancy in common. So obviously those are quite common, especially selling your interest or mortgaging your interest if you are having money difficulties. That might obviously happen. So let's have a look at each of them in turn. So if you say your equitable interest to someone else and you basically give the other person the rights to live at the property, for example, or to enjoy any proceeds from it, then that will sever the tenancy. For example, if Alice and Bob are the original joint tenants and Alice then sells her interest to another person, Carl, then Carl and Bob are now tenants in common. They will have equal shares, and because it's a tenancy in common, there's no longer the rule of survivorship applying, and they can now decide who they will give their share to when they die. Okay. Now, if you gift your share, that works basically the same way. Just obviously that there's no consideration there, and you don't get any money in return. But otherwise, it works exactly the same way. First, you were joint tenants, then you give the interest to another person, and that acts as a severance, and the effect will be that the title is now held in common. Okay. Then lease of your share, that could also count as severing. So for example, if Pfizer and George own a flat together, but Pfizer then leases out his beneficial share to Hannah for 10 years. Maybe he wants to go abroad for some time, so he thinks Hannah can have the property as on lease and just live there for those 10 years until I come back. That would work, for example, and because the share is basically leased out to another person, that acts as a severance, and the joint tenancy is now turned into a tenancy in common. Then we have mortgage of your share, which should be fairly self-explanatory. If you, for example, you live in a property or you rent it out or whatever, and then you get a mortgage and use that as collateral or security, then this mortgage will also count as severance, and immediately the joint tenancy is turned into a tenancy in common. Now, the last point here is closely related to the first one. So the thing is, even if you are just trying to set up a sale, you think, yeah, I don't need the property anymore, I want to sell it to someone else, and then maybe buy a different item, or I don't know. It doesn't really matter if there's any issues later on with the property. Maybe there's an issue with the deeds, you don't have all the signatures, or you don't have a witness, and so on. There can still be severance if you at least have a binding contract for the sale. So you might remember that from previous lessons, that equity sometimes steps in if there's an issue with the formalities of a deed. And the same thing happens here as well, because equity can still recognize the severance, even if the formalities of the deeds and everything are not fulfilled exactly as they should be. So you might want to have a look at those earlier lessons if you're a bit unsure about that aspect, okay? Now, mutual agreements, that's the only one where you necessarily have both or all tenants agreeing on severing the tenancy. So in that case, since everyone is basically agreeing, the law doesn't really require any kind of formalities. You can just do that in a conversation verbally. There's no need for there to be any writing even. It can be just something that is really kind of casual. So if you're interested in that kind of thing, you could have a look at, for example, at the case of Burgess versus Rawnsley. So in that case, a couple agreed to buy the other's share for even just £750, and later on the deal kind of fell through, didn't go ahead. But because they had a binding contract for those £750 and they'd agreed on a sale, then equities, they stepped in to secure the severance and say, well, you've definitely shown an intention that you wanted to divide the property up into shares, so that's exactly what we would do. Then we have course of dealings. So to some extent this is a bit self-explanatory, as it works on a lengthy course of conduct really. So if the co-owners act over time, repeatedly, consistently, as if they actually own separate shares, then the court can basically confirm this course of conduct. So I don't know, for example, there's two owners of a property and they are renting out the property, and they split the income from the property and treat each share of the income separately, so they can each do whatever they want with it. Then obviously, because they're splitting all the proceeds from the property, then the court could say, yeah, well, you've been treating this tenancy as a tenancy in common, like with shared different shares all this time, so we will just confirm that. And it's not just about a single act, it's about how the co-owners collectively behave over a longer period of time. And then each time they act, they basically confirm this intention to treat the property as if it's held with separate shares. Okay. So the question really is, do they treat themselves as if they own separate shares? And if so, then it can be severed, even though there's no formal steps that have been taken to really conform the severance. One example is like when the parties negotiate about splitting the property, and they never really formalize it, but all this time they've been saying, yeah, maybe we should go 50-50, or maybe it's like 40 and 60%, and then they never really agree to it, and there's a bit of a back and forth. But obviously, even though there's different positions there, all of them show an intention to have separate shares, and so in that case equity might still step in and say, well, look, we will just sever the property because that's what your conduct is actually showing us. So for example, two siblings inherit a house and that's given to them as joint tenants. Now over the years they keep arguing and negotiating because they do want to divide the property, but they never really formalize it, and maybe there's a bit of a back and forth and they don't necessarily agree on the exact amount of shares, but the courts might still treat this as severance. Another example would be where they all collect rent from tenants and split this up as if each person had a defined share. So that's the earlier example I indicated. Okay. So basically what we can take from this course of dealings applies even without a formal severance, provided we can see any kind of evidence of an intention to divide the property into separate shares. So this can be negotiations, it can be discussing a future sale, it can be renting out a property. Any kind of evidence should suffice, as long as it's something that's not a one-off incident, but it's a repeated course of conduct. So that's what really separates acts on your own share and course of dealings. So if you are unsure what's what, this table should help you decide. So acts on your own share are actions that one co-owner is taking, and severance happens immediately upon that one single act, even if it's something that's just unilateral without any kind of agreement. By contrast, a course of dealings is something that happens collectively by all the tenants over a long period of time with repeated behavior, like for example repeated negotiations or repeated discussions about selling the property. And in that case, we can kind of infer from this conduct, this mutual conduct, that they've wanted to sever the shares all this time. So, for example, if we've got Bob and Alice who are renting out their property to another party and then they split the rents 70-30 over a long period of times, maybe a couple of years. This shows that they have always treated the property as divided, and so the court may infer severance from this course of conduct. I've already mentioned that there are a couple of more methods of severance which are more to do with the circumstances. So, for example, if one person goes bankrupt, you automatically transfer your shares to the trustee in bankruptcy, and that means that it will be severed. So this kind of goes beyond the scope of land law a bit into like law of organizations, business law, and so on. But for the sake of this video, just remember that bankruptcy is a method of severance as well. A bit more dramatic, if you unlawfully kill a co-owner, you cannot then inherit that share. So this is also called the rule of forfeiture. So, for example, if you've got a couple who own a property together, if the husband then kills the wife, obviously they cannot just simply profit from the murder and then basically keep all the property from themselves. That would not be allowed by the law, because they think, no, you should not be rewarded for something as awful as murder. And so this prevents the rule of survivorship from taking effect, and you cannot then inherit the share from the person that you killed. And then lastly, this is a bit more complex, but for example, if you buy a property and initially you each provide equal contributions to the deposit and so on, but then maybe a bit later on your circumstances change, one person loses their job, for example, so all of the following mortgage payments, there's a huge difference in contributions, and one person is basically paying for all the mortgage, and the other person isn't really making any contributions anymore. This could be seen as a intention to divide the property into shares, and so belatedly we could say that it's being transformed into a tenancy in common because of those unequal contributions. So what are the effects of severance then? This kind of depends a bit on how many tenants there were originally. If there were only two joint tenants, which is the most common case, they would then become tenants in common, and normally they will all have equal shares unless this is specified because of, I don't know, contributions and so on. Now, if you have more than 2 tenants, then only the person who does the severing gets to take their defined share and is now treated as a tenant in common. But all the other ones who didn't even take part in all this, they still remain joint tenants together. And to them, the rule of survivorship and everything else still applies. So, just 2 examples to make this a bit clearer. Imagine we've got 2 tenants only this time, which are Harry and Zima. And obviously they were joint tenants in the beginning. Now Harry, he said his equitable interest to Joseph. And if you remember from the previous slides, if you sell your property, your interest, then this automatically means that there is a severance. So now Joseph and Zima are tenants in common and not joint tenants anymore. Okay, and obviously because it's a tenancy in common now, the rule of survivorship doesn't apply anymore, and you can specify in your will who you want to give your share to. Okay, and then if we have by contrast 4 tenants, this works quite differently. So for example, we've got 4 tenants in the beginning: Amy, Ben, Clive, and Diana. And they are all 4 joint tenants. Remember, 4 is the maximum of amount of joint tenants we can have. Ben then decides he wants to share and sell his interest to Fiona. And as before, the selling of the interest immediately severs the tenancy. But the difference now is that only Fiona, so the purchaser, is now seen as a tenant in common who's got a divided share, a specific share, and who can also give their share to another person in their will. So Fiona now owns 1/4 of the property as a tenant in common, and that's a specific share that only belongs to her. The other 3, so Amy, Clive, and Diana, the other 3 original tenants, they still hold the rest of the property as joint tenants, and to them still the old rule of survivorship and everything applies, and each of them has the rights to the whole of the remaining property. So that's important to keep in mind what happens depending on how many tenants there actually are. Okay, so just to summarize this, severance is basically how we change a joint tenancy where everyone is owning the property together into a tenancy in common where everyone has separate shares, or at least one person has separate shares. So this only affects the equitable ownership and not the legal title. That's really important to remember. It's only in regards to the beneficial interest. So for example, who gets to live there, who gets to enjoy the benefits, who gets to get the proceeds from any kind of renting and so on. And there are a couple of ways that this can be done. So for example, notice, agreement, and action. So those are things that actually requires some kind of action taking place, or there could be some other circumstances like the bankruptcy, like a murder, and so on. But each of those methods can lead to severance, so they can basically ensure that the property is divided up and the shares are being allocated amongst the tenants. And if this happens, or if the shares get allocated and divided, then naturally the rule of survivorship has to end, and now the shares will get passed on according to whatever is written in each person's will. Okay, that's basically